Welcome to Steve and Tamara Explain Corp's Law, the podcast where two entirely self-appointed experts pretend to know more than they actually know about companies, directors, shareholders, and the occasional legal catastrophe.
This is the place where we take the cases, legislation, and big corporate theory ideas you're meant to understand, and then immediately make them sound much less serious.
So grab a coffee, open your textbook, and let's get into today's episode of Steve and Tamara Explain Corp's Law. Great. So we've had a really good discussion there a bit about the background of different kind of corporate interests in the corporation. And now we're going to get to the kind of main case or the case that we were that you're going to discuss really here. The Sons of Gwalia case, what happened and what was the parliamentary response?
Yeah. Okay. So Sons of Gwalia was a gold mining company, which I feel like is quite cool. They were, like big gold mining company, but in 2004, they went into administration or became insolvent. One of those two. Maybe both.
Mine of one.
Who knows? So the issue arose because the Sons of Gwalia directors, Gwalia was a publicly listed company on the ASX, and the directors had been complying with their continuous disclosure obligations, but they had been providing some slightly fudged information.
All right, okay.
So what they had been saying was that Sons of Gwalia, the company, had enough gold reserves to meet all of their existing contracts to sell gold.
Right.
Not true.
No, okay.
Unfortunately.
Yeah.
They thought as a backup, if they didn't have enough gold to meet their contracts, they would be able to buy gold from the market to sell. Essentially.
Okay.
It's going to cost them more money, but it's fine.
Yeah, okay.
Unfortunately, what happened to throw a spanner in the works was that the price of gold rocketed up.
Right.
So all of a sudden, they not only had insufficient gold to meet their contracts, but they really couldn't afford to buy the gold that they needed to satisfy those contracts. So they had been, slightly fudging this in their continuous disclosure. So before all of this became...
Slightly fudging.
It's the legal term.
The legal term, yeah.
Before this became public, various shareholders were, always buying and selling Sons of Gwalia shares on the ASX. And one of the shareholders who purchased shares was, I think, called Margaretic. He was the one who ultimately brought the action, supported by a litigation funder, interestingly. I looked up the litigation funder, which I think was IMF. And they have, allegedly on their website, they say they have a 90% success rate, the litigation that they fund, which is fascinating in a whole other realm. Well. So, I love those legal ethics.
Yeah, that's going to be one of your legal ethics.
Yeah. Absolutely. So Margaretic had purchased these shares and then, paid a certain price for them. And then the Sons of Gwalia directors had no choice, essentially, but to come clean with the actual state that the company was in, because they couldn't afford to buy this gold. And so they, made that public on the ASX as they have to do, and their share price tanked overnight.
Surprise.
Yeah. The ASX then delisted them because they hadn't complied with
the rules.
The very strict investor protection rules. And the share price then, whatever was left of it collapsed even further because they'd been delisted. So Margaretic sued the Sons of Gwalia company directors, and what he wanted was to get back the price he paid for his shares plus brokerage fees.
Right.
Which, all things considered, is not such an unreasonable request given that the company directors were...
What was it, slightly fudging?
Slightly fudging the information.
Yeah.
So the allegations were that the directors had breached their directors' duties and that they had supplied misleading and deceptive information, which they
Again,
had.
kind of makes sense that would be the claim.
Yeah, exactly right. So none of that was particularly contentious. This case was heard by the High Court, and, yes, it was misleading and deceptive information provided by the directors. Where the contentious issue came was that the High Court decided, not unanimously, there was some vociferous dissenting going on here, but they decided that Margaretic's claim to have his share price money and brokerage fees reimbursed would not be subordinated behind all of the claims of the creditors, which is how, as we talked about, how insolvency law generally works. And they looked at the wording of Section 563A of the Corporations Act, which said that members in their capacity as members rank behind creditors or debts owed to members in their capacity as members. And they said, High Court said, well, Margaretic's, amount that he was owed was not in his capacity as a member because it was an action essentially under the Australian consumer law, misleading and deceptive.
It was a damages award.
Exactly right.
Yeah.
So that was it was a hot take.
Yeah.
Based on the way that they interpreted the Corporations Act, I think it was open for them to make. They could decide whether it was in his capacity as a member or not. Like, I hear they're quite learned and educated, able to make a decision.
But really interesting. It's a big decision, right?
Massive.
Because it kind of changes everything.
It does. It does. And it really kicked the anthill. So the decision was in 2007. And so all of a sudden, everyone's writing articles about like, oh my gosh, like, is everything we knew about insolvency law incorrect?
Yeah.
And really, as you said, really big departure to treat, even in this sort of like limited niche circumstance, to treat the interests of a shareholder as ranking equally with the interests of creditors.
Yeah. Interesting.
Now, something to keep in mind is that realistically, this amount was only going to be paid to Margaretic if they ranked him equally, his claim equally with the creditors. Because what happens in not every, but most insolvency is that the debts owed to the creditors probably will exceed the company's liabilities.
Yeah.
And so the creditors will be paid out, maybe not even entirely, and their shareholders get nothing. That's not always the case. Sometimes the shareholders get a little bit
something at the end.
But certainly that's not necessarily an expectation that you're going to have. So even though there was this valid claim for damages, if Margaretic's claim ranked behind all the creditors, there's very good chance that it would never be paid.
It's an interesting thing to ponder, right? Like to ponder.
Let's ponder.
When have I said ponder?
Well, just now.
Just now. And it will be forever recorded. So it's an interesting thing to think about or to ponder. It seems like a legitimate claim, right? Like you've gone and showed through going through litigation and reaching all the way to the High Court in this instance that you've had this kind of damage done to you because of a breach of law. And then the outcome, if a different decision was made, would be that you rank behind the creditors and ultimately not receive anything.
Your vindication of your hurt feelings. Yeah.
So that's an interesting thing to think about when we're looking at shareholder protection. And versus creditor protection, which is how we started the discussion today.
And it's a really interesting intersection of insolvency law, corporations law, and Australian consumer law.
Consumer law, right.
Which all have, I guess, different aims that are coming into conflict.
Yeah.
So Parliament was not happy with the Sons of Gwalia.
I think others were not happy, so then Parliament ultimately.
Well, yes, certainly.
The parliamentarians are sitting there thinking like,
aggrieved.
Sons of Gwalia case. Maybe they were.
Maybe they were. Yeah, I mean, maybe they're creditors.
Yeah, well.
And so the High Court had essentially said in their decision, they were like, we're going to interpret the Corporations Act, Section 563A, as we see it. And if Parliament intended for it to be interpreted in a different way, then of course they're open to...
I love that when the court does that. It's like, this is it, but, if you want to deal with it...
Then by all means,
go for
it. Go off, gal. In 2010...
Oh, we're getting serious.
Well, not really. I just need to read one line from the Corporations Act.
Love that.
They introduced I've got my...
What is that?
It's Vulpix.
I don't know.
First generation Pokemon.
I'm not a Pokemon person. Sorry.
This podcast
it's done. We're done now.
It's
finished.
In 2010, the Parliament introduced the Corporations Amendment Sons of Gwalia Act. They named it after.
I wonder what they were dealing with.
I can't imagine. They made a few changes, but the really material one I want to highlight is in Section 563A of the Corporations Act. The payment of a subordinate claim against a company is to be postponed until all other debts payable and claims against the company are satisfied. So far, so normal. And they define subordinate claim as a claim for a debt owed to the company by a person in the person's capacity as a member of the company, consistent with the prior law. Then they inserted this one: any other claim that arises from buying, holding, selling, or otherwise dealing in shares in the company.
Right.
So they're saying yes, all right, maybe technically these damages didn't arise in your capacity as a member.
Yeah.
but it still arose from you buying shares.
Yeah, because you bought these shares, you became a shareholder, and this bad thing happened to you because of that.
Yes. And so essentially, if we had, I assume this is how it's intended to work, if we had some other damages owing to a shareholder completely divorced from their status as a shareholder, like not involving their shares.
Yeah.
Like the directors had punched them. Like, I don't know. Then I think that the way that the court dealt with it in Sons of Gwalia might still be in accordance with the law. But certainly for Margaretic, because his claim for damages rose out of his buying the shares, which were then severely devalued, he would not be put in that position.
Yeah.
He would rank behind the creditors.
So what's the kind of what do you think are the implications then, or where are we now?
So basically now we're in the position, and I'm sure our audience member is going to love this, which is that Sons of Gwalia has somewhat of the status of a historical relic because the law has been changed. But actually people still refer to this decision, particularly when trying to decide when something is within a person's capacity as a member or not.
Yeah, interesting.
Yeah.
Yeah.
So from the insolvency perspective, we have had the status quo returned where all shareholder claims rank behind all creditor claims.
If I think of this case at a more meta level, well,
Please.
I love to get meta.
Please be meta.
I love to get meta. So I kind of think of possibly three things.
Sure.
First of all, it's interesting to look at a time where there were really big, bold decisions being made, right?
Yes.
Because sometimes you get a sense that we're so baked into the current system that these big decisions are really difficult to make. But there was a time not so long ago where the High Court was willing to come out and say, well, we're going to view it in a completely different way. And it caused Parliament to then intervene. The second thing that it shows for me is like this ongoing kind of debate between the courts and Parliament in Australia generally, but particularly the potential significance that has in corporations law.
Yeah.
And the third thing, I would love to see what would happen now, right?
Yeah.
Because we're also at a different, I think, time in terms of corporate governance where we're looking at the interests of other stakeholders.
As we talked about.
And so this is going back to that discussion that we had. Here the court and Parliament and the outcome, I guess, was very clearly what we expected. Shareholders get protected to a certain extent, and creditors in insolvency have their supremacy.
Yeah.
But in this case, the shareholder was also treated as a kind of a vulnerable person, consumer.
Yeah.
And to think of that as a stakeholder, how we protect them. It's interesting to again ponder what would really happen in these kind of circumstances now.
Yeah.
Maybe the same, but it's just something to think about.
Yeah. No, I think you're right. I think there's a lot of really interesting philosophical outcomes. That remain and questions that it gives rise to, which is why I found it such a fascinating case to discuss. And I'm glad.
Hopefully the one viewer does as well. Yeah.
And thank you for humoring me and letting me talk about this case.
Love hearing about it.
Because I really enjoy going down rabbit holes.
Love it. All right, thank you.
Excellent.
And we'll be back with more on other stuff.
More fun corpse law facts.